The envelope arrived without warning, not by mail, not by phone call, by silence. The kind of silence that falls over an office desk when a senior immigration attorney stares at a visa bulletin and does not blink for 30 seconds straight. Because what the March 2026 Visa Bulletin said, on the surface, looked like good news, dates moving forward, categories going current, windows opening, but underneath that surface, buried inside 3 lines of official language that most H1B holders never read, was a warning. A quiet, official, government-issued warning that retrogression may be coming. And if you are an H1B worker right now, whether you are on your 3rd extension, your 5th year waiting on an I-485, or still waiting for your I-140 to clear, that warning is not for someone else. It is for you. Most people saw the headline and celebrated. They shared the bulletin in WhatsApp groups. They told their families back home that the green card was finally close. That is the trap. And today, you are going to understand why, before it is too late. For months now, there had been signals coming from inside the Department of State and USCIS, not from press conferences, not from official announcements, just signals, that the employment-based green card system was being repositioned for something unusual. The fiscal year 2026 had started with steady forward movement. October 2025, November, December, January. Each month, dates advanced. Each month, USCIS chose the dates for filing chart, 5 consecutive months in a row. For H1B workers watching from the outside, it felt like momentum, like the system was finally moving in their favor after years of frozen dates and broken promises. But immigration attorneys who monitor the visa office patterns recognized something else in that movement. They recognized a strategy, a deliberate repositioning, a pipeline being built not to deliver green cards faster, but to create a reserve of applicants that the government could manage going into the back half of the fiscal year. Because when the government advances dates this dramatically, this fast, it is almost never just generosity, it is math. And in the math of visa allocation, what goes sharply forward has historically, almost without exception, come sharply back. The indicator was the language, not in the tables, not in the dates, in 3 lines of standard bulletin language that most people skip entirely. It said, retrogression may be necessary later in the fiscal year to keep issuances within annual limits. That sentence, right there, in the March 2026 Visa Bulletin. Not theoretical, not hypothetical, an active live warning issued by the same government body that controls whether you get your green card this year or wait another decade. And when the visa office issues that warning in the same bulletin where EB2 just moved to current for the rest of the world for the first time since November 2022, something loud is coming. Early February 2026, the Department of State released what immigration attorneys immediately described as one of the most consequential employment-based bulletins seen in years. EB2 filing dates for India surged forward by 335 days. Not weeks, days. Nearly a full year of movement in a single bulletin cycle. EB2 for Mexico, Philippines, and all other countries went to current on the dates for filing chart, completely open. File now. EB1 filing dates for India and China also advanced significantly. USCIS confirmed it would use the dates for filing chart for March, the 5th consecutive month it had made that choice. To the untrained eye, this looked like a government finally clearing a backlog that had paralyzed skilled workers for years. But former Visa Office Chief Charlie Oppenheim, one of the most respected analysts of Visa Bulletin mechanics in the country, described this month's bulletin as less about movement and more about strategic positioning for the remainder of fiscal year 2026. That is not a quote you celebrate. That is a quote you study. Strategic positioning means the government is building a reserve. It means they are getting applicants into the pipeline now, not to approve them now, but to have them ready to absorb visa numbers that might become available later, potentially from unused family-based allocations or from the ongoing visa pause affecting approximately 75 countries since January 21, 2026. And it means that if demand surges in response to these advanced dates, which historically it always does, the numbers get exhausted faster than the visa office projected. And when numbers get exhausted, there is only one direction the dates can move: backward. The retrogression warning issued inside the March 2026 bulletin was not routine. It was not symbolic language placed there out of legal habit. It was urgent. Attorney after attorney, in analysis after analysis published in the 3 weeks since the bulletin dropped, described the warning as real, as active, and as the single most important thing an H1B holder needs to understand right now. One immigration law firm described the forward movement as exciting for thousands of immigrants, but immediately followed that with a structural caution. When we see dramatic forward movement, it is often followed by stabilization or even retrogression later in the fiscal year. Another analyst put it more directly. The Visa Bulletin is not a promise. There is always a possibility that the State Department and USCIS could regress the dates. But strategy only works if the other side hesitates. H1B workers who understand this do not hesitate. Their response to retrogression risk is not panic. It is preparation. It is action. It is filing before the window closes. And the attorneys who are watching this most closely say the response window right now is among the shortest and most consequential seen in the employment-based system in over a decade. Here is exactly what the March 2026 bulletin confirmed, broken down so that every H1B holder knows precisely where they stand today. There are two charts that control your green card timeline: the final action dates chart and the dates for filing chart. The final action dates chart controls when USCIS can actually approve your green card and grant permanent residence. This is the chart that actually makes you a permanent resident. The dates for filing chart is different. It controls when you can submit your I-485 adjustment of status application. You cannot get your green card yet, but you can get into the system. You can file, and once you file your I-485, you get something extraordinarily valuable. You get work authorization. You get travel permission through advance parole. You get a protection layer around your immigration status that an H-1B alone cannot give you. USCIS confirmed it is using the dates for filing chart for March. That means if your priority date is current under that chart, you can file your I-485 right now. For EB2 India, the dates for filing date is now set at a point that covers hundreds of thousands of applicants who have been waiting for years. The final action date for EB2 India moved only 1 week, to October 1st, 2013. That means your green card itself is not coming tomorrow, but your ability to file, to protect yourself, to start the clock, that window is open today. For EB2, rest of world, Mexico, and Philippines, that window is completely open. Current, no waiting. File now. For EB3, dates moved between 2 and 17 months in most categories, with EB3 China holding at September 1st, 2019 on final action dates. For EB1, the bulletin carried a specific warning. EB1 worldwide could retrogress. The category is currently open for everyone, but it may not stay that way. This is not a drill. Now here is what makes this moment uniquely dangerous for H1B workers specifically. Your H1B gives you the right to work. It gives you a status. It gives you a path. But H1B has limits. It maxes out at 6 years unless you have an approved I-140 petition. Once you have that I-140 approved, and if your priority date is not yet current, you can extend beyond 6 years in 1-year increments. But those extensions are dependent on the system functioning. They are dependent on your I-140 remaining valid, your employer continuing to sponsor you, the policy environment remaining stable. Right now, none of those things are guaranteed. The immigration environment in early 2026 is defined by volatility. The same administration that paused immigrant visa issuance for nationals of approximately 75 countries in January 2026, citing public benefits concerns and enhanced vetting requirements, is the same administration overseeing USCIS today. The same system that advanced EB2 India by 335 days in March could retrogress it by the same amount in April, May, or June. And if that retrogression happens while you are still waiting, still on H1B extensions, still assuming the dates will hold, you lose your window. You do not get a second warning. The bulletin language makes that explicit. Once a category reaches its annual cap, it will immediately become unavailable with no further requests honored. Immediately, no further requests honored. That is the sentence every H1B holder on a long-waiting priority date needs to put somewhere visible in their home. The attorneys who are advising clients right now are saying the same 4 things. First, confirm your priority date immediately. Pull your I-140 approval notice. Identify your preference category. Know your exact position in the queue. Not approximately, exactly. Second, if your priority date is current under the dates for filing chart, begin gathering your I-485 package now, today, not next week. The materials required for an adjustment of status application take time: medical exam, biometrics appointment, financial documentation, employment letters, tax records, police certificates. Start immediately. Third, do not wait for your final action date to become current before filing. The dates for filing chart exists precisely for this situation. Filing your I-485 early does not mean you become a permanent resident early. It means you are protected while you wait. Fourth, if you are a national of one of the approximately 75 countries affected by the January 21st, 2026 consular processing pause, pay special attention. The domestic adjustment of status pathway remains open for you if you are inside the United States on valid non-immigrant status. Consular processing may be frozen. The domestic path may not be. That distinction could be the difference between a green card and another 5 years of waiting. There is one more layer to this story that most people in WhatsApp groups and community forums are not talking about. The reason EB2 and EB3 dates moved this dramatically in the first place is connected to something entirely outside the employment-based system. The State Department's pause on immigrant visa issuance for nationals of approximately 75 countries, which began January 21, 2026, primarily affects consular processing of family-based categories, IR1 marriage green cards, family preference categories processed at embassies abroad. When fewer family-based green cards are issued overseas in a fiscal year, those unused numbers have historically spilled over into employment-based categories. The government does not announce these reallocations in real time. They simply appear as forward movement in the Visa Bulletin. What immigration attorneys are seeing in the March 2026 Bulletin is exactly this mechanism at work. The pause on consular processing created an anticipated surplus of numbers. That surplus was redistributed. Employment-based dates moved forward as a direct result. But that redistribution is temporary. It is dependent on the pause remaining in place. It is dependent on demand not surging past the available numbers. It is dependent on a dozen variables that no applicant and no attorney fully controls. Former Visa Office Chief Charlie Oppenheim called this month's movement preparation for potential late-year movement, not a permanent recalibration of the system. The system did not fundamentally change. The window opened, and windows close. This is what the moment actually looks like for an H1B holder in March 2026. You have been in the United States for years, possibly over a decade. You have built a career here. You have a family here, maybe children born here who are American citizens by birthright while their parent waits on a visa queue that moves 1 week at a time. You have filed your I-140. It was approved. You have a priority date. You watch every bulletin the way a farmer watches weather reports, knowing that one shift in the forecast can change everything. This month, the forecast shifted, dramatically, in your favor, on paper, but the warning is also there, in writing, from the same government office that controls your future. The attorneys are unanimous. The data is clear. The history of this system confirms it. This is not a moment to celebrate and wait. This is a moment to move. Check your priority date today. Call your immigration attorney today. Start gathering your I-485 documents today. Do not assume the dates will be the same next month, because when EB1 retrogresses, and the bulletin is warning it may, and when EB2 India pulls back after the filing surge that is already beginning, the people who acted in March will be protected, and the people who waited will be starting over. As this fiscal year continues, more details will emerge about how the Visa Office manages the surge in filings that this bulletin is expected to trigger. But one thing is already clear. Understanding this right now does not make you paranoid. It makes you prepared. It means you are protecting your status, your family, your future. Share this video with every H1B worker you know, with every EB2 applicant in your network, with every family member who has been waiting on a priority date for years. It might save their green card. Subscribe to Visa Status Radar for more protection. We protect you with real information as the next phase of this bulletin unfolds.